Good morning, everyone. I will now call this meeting of the Standing Committee on Government Operations to order. My name is Rylund Johnson. I am the chair of this committee and the MLA for Yellowknife North. Today we are holding a public review and clause by clause of Bill 62, an act to amend the Income Tax Act number 2. This bill makes a number of amendments to the act to update the act in light of recent Income Tax Canada amendments by allowing the communication of information between governments in the Northwest Territories and Canada, removing federally repealed provisions, making changes respecting various COVID-19 relief measures, making the Act conform with the Canada Northwest Territories Tax Collection Agreement, including a reference to allow or disallow deductions in calculating the federal foreign tax credit, and removing ambiguity respecting tax on split income for multi-jurisdictional tax filers. Today's meeting is being live streamed on the assembled social media channels. I would like to remind all members and witnesses to please direct comments and questions to myself as chair. This will help keep the meeting organized and running smoothly. I will now ask members to introduce themselves for the record, beginning on my left.
Kevin O'Reilly, Framelink.
Richard Jarek, MLA for Trinity Validity Writing.
Frida Martzellos, MLA for Debatcha.
Caitlin Cleveland, Cam Lake.
Thank you. And with that, Minister, I will turn it over to you to present the bill.
Thank you very much, Mr. Chair. I thank you for providing me with this opportunity to present Bill 62, an act to amend the Income Tax Act. With me today is Deputy Minister William McKay. Beside me, Deputy Secretary to the Financial Management Board, Terence Coutre, seated behind, Legal Counsel, Christina Duffy, Director of Fiscal Policy, Kelly Bluck, and Manager of Tax Policy, Kim Vu. I hope I've pronounced everyone's names correctly. Also Drew Robertson-Story, also seated behind me, is my senior advisor. The main purpose of Bill 62 is to make various legislative retroactive housekeeping measures to the territorial income tax legislation to comply with the Canada Northwest Territories Tax Collection Agreement. These agreements and these amendments keep territorial legislation current and harmonized with the federal income tax legislation. Specifically, the proposed changes include the following. 1, to remove a reference to a repealed federal provision about an option for trusts to pay tax. To exclude a reference to the federal COVID-19 relief measure for an additional GST/HST payment. To exclude a reference to the federal temporary wage subsidy under COVID-19 relief measures. To include special federal rules for determining the Northwest Territories child benefit as part of COVID-19 relief measures, and to include a reference to the federal special rule for the disability supports deduction as part of COVID-19 relief measures. To align the Northwest Territories Act with the federal administrative rules in compliance with the Canada Northwest Territories Tax Collection Agreement. To include a reference to federal rules on evidence for notices sent to persons in compliance with the Canada Northwest Territories Tax Collection Agreement. To include a reference to federal provisions relating to certain allowed or disallowed deductions in the calculation of the federal foreign tax credit. To remove ambiguity in certain terms relating to tax on split income for multi-jurisdictional tax filers. Bill 62 includes also an amendment to allow the Canada Revenue Agency to share Northwest Territories specific taxpayer data with Finance Canada. Sharing this data with Finance Canada assists in designing tax policy and benefits the GNWT by allowing Finance Canada to provide a more detailed analysis of the implications of federal tax measures on the territorial tax system. Canada Revenue Agency has a number of stringent security agreements in place to safeguard Northwest Territories taxpayer data from being used inappropriately. We have also provided the Standing Committee with a motion to correct language in the coming into force provision, current section 13 in Bill 62, with a new section showing the correct effective dates of the bill. After the bill was introduced, it was discovered the effective dates contained in the bill did not agree with the various federal measures that had different retroactive effective dates. Without the proper effective dates, the Canada Revenue Agency will not comply with the income tax legislation when administering the territorial income tax regime. Mr. Chair, that concludes my opening remarks, and I'd be happy to answer questions committee may have.
Thank you very much, Minister. Are there any questions or comments from committee? MLA O'Reilly?
Thanks, Mr. Chair. So in the Minister's opening remarks, she mentioned that the bill contains provisions to allow information sharing between Canada Revenue Agency and Finance Canada, I guess, but also GNWT. So I know that the Standing Committee on Government Operations has raised the issue of whether GNWT can provide greater disclosure around the use of tax credits and what the cost of those tax credits are to Northwest Territories taxpayers. So will this provision allow for the sharing of tax credit information with GNWT now? And allow, say, our Department of Finance to agree with SCOGO's recommendation on greater disclosure of tax credit information. Thanks, Mr. Chair.
Thank you, Minister.
Oh, sorry. Thank you, Mr. Chair. Mr. Chair, yes, it's my understanding that that would allow for the greater disclosure as to what the CRA or Finance Canada may then decide to do with that, or how they may decide to administer their system. I wouldn't be in a position to say. Thank you, Mr. Chair.
Thank you. Yeah, it's committee's experience. We passed a couple of amendments to the Income Tax Act that require us or allow us to share information with Finance Canada, but it doesn't necessarily mean they share the information back with us despite collecting their taxes. So I know the minister has followed up trying to get information out of the CRA before, but it can be difficult. Emily O'Reilly, any follow-up?
Thanks. Yeah, I'm glad to hear the minister say that, and I'm sure I'll look forward to a positive response now to that SCOGO recommendation when the government responds. And I might raise this on the floor as well. But the other point I guess I want to ask about, Mr. Chair, is the minister also talks about some changes to the in-force date of the legislation. And I guess, can I speak to those now, Mr. Chair? Because the minister raised this. So when I look at what these changes are in terms of when different provisions come into force, one of them is retroactive to like 5 years ago. Does this mean that we've been sitting on this change for 5 years? And if so, and some of the other changes aren't quite as dramatic, but some of them go back 3 years almost. Why weren't these changes brought forward earlier? And did we actually lose any revenues as a result of these changes not being brought forward sooner? And if the minister doesn't have the lost revenue information at her fingertips, I'd be happy to get that before the bill comes up again in committee of the whole. Thanks, Mr. Chair.
Thank you, Minister.
Thank you, Mr. Chair. Mr. Chair, with respect to the why, if I might turn that to Kelly Black, please.
Go ahead.
Thank you, Mr. Chair. The reason why the effective dates are so late is because you have to wait for the federal government to make their changes in the legislation as well. And so what they have done is they provide to their administrator, the Canada Revenue Agency, the indication that change is going to be made, and then they administer the income tax based on that change until the change actually happens. And we have to, then in our legislation, we will not make that change in our legislation until, in fact, the federal government has made theirs. So some of this is that because the federal government's legislation was so slow in getting through their house, then we do not make our amendments to our Income Tax Act until such time as those actually happen. But the intent is provide the intent to the Canada Revenue Agency that this legislation will be changed, those effective dates will happen when we have to, in order to comply with the tax collection agreement. At which point, if it doesn't pass, then we are responsible for the costs to re-comply with the income tax legislation that has already happened.
Thank you. Any follow-up, Emily O'Reilly?
Okay, thanks. So can the minister then provide the information as to when the federal legislative provisions were passed for each of these new dates for when different sections are going to come into force for each of them, and whether we lost any revenues as a result of the delays? Thanks, Mr. Chair.
Thank you. Minister?
I'm going to answer the second question first, which is it's my understanding that there was no losses of revenue. These aren't items that would have resulted in loss of revenue. Certainly, if I'm incorrect with that, we'll confirm, but that's my understanding at this point. As for the various dates of other legislation by another level of government, we'll have to come back on that. I don't have that. I mean, the explanation here is that we've made our dates compliant with their dates. But if you'd like us to go and double check that, I guess we will go and double check that.
Thank you. Any further questions, comments from committee? Hearing none. Are there any members from the public who want to present on the Income Tax Act number 2? Seeing none, does committee agree to proceed to a clause by clause today? The committee agrees to conduct a clause-by-clause review of Bill 62 and act to amend the Income Tax Act number 2. There was one motion to be moved at the request of the government. I will pass that to MLA Cleveland.
Thank you very much, Mr. Chair. Mr. Chair, I move that Bill 62 be amended by deleting Clause 13 and substituting the following. 13 brackets 1, subject to subsection brackets 2 to bracket 6. This act is deemed to have come into force January 1st, 2022. 2, subsection 4 is deemed to have come into force January 1st, 2023. 3, subsection 5 brackets 1 is deemed to have come into force January 1st, 2018. Number 4, subsection 5 brackets 2 is deemed to have come into force July 1st, 2021. 5, section 6 is deemed to have come into force March 25th, 2020. 6, section 8 is deemed to have come into force March 25th, 2020. And that is the end, Mr. Chair. Thank you.
Thank you. The motion is in order. To the motion. Members, if you could say question. Question. Thank you. Question has been called. All those in favor? The motion is carried. Minister, do you concur with the motion?
Yes, Mr. Chair, thank you.
Thank you. We will now proceed with the clause by clause of Bill 62, Income Tax Act number 2, as amended by the motion. To clause 1, does committee agree?
Agreed.
I guess I will go through. I will go through all of these. To clause 2, does committee agree? Clause 3. Clause 4. Clause 5. Clause 6. Clause 7. Clause 8. Clause 9. Clause 10. Clause, what did I just say, 10? Clause 11. Clause 12. Okay, and clause 13 as amended by the motion. Does committee agree? Thank you. Does committee agree that Bill 62, an act to amend the Income Tax Act number 2 as amended, is now ready for consideration in committee of the whole? I will pass this over to MLA Cleveland to move this into committee of the whole.
Thank you very much, Mr. Chair. Mr. Chair, I move that Bill 62, an act to amend the Income Tax Act number 2, as amended, be reported to the Assembly as ready for consideration of committee of the whole. Thank you, Mr. Chair.
Thank you. Motion is in order. To the motion. Question has been called. All those in favor? Motion is carried. Bill 62, an act to amend the Income Tax Act number 2, as amended, will be reported to the Assembly as ready for consideration in committee of the whole. Thank you, Minister Wozniak and staff, for presenting today. This concludes the public portion of our meeting.